everyone, and welcome to Thorough Newspaper Analysis, which is presented to you by LawSikho. So today again, we will be discussing three articles, but two of them we have clubbed them together. So the first article or the group or set of articles is "Say No to Corporate Houses in Indian Banking," which is from the Hindu, and "Corporate as Banks." Key issues, which is from the Indian Express. So basically, this talks about the recent discussion that has been going on regarding giving the power to corporates to turn as banks as well in India or to own private banks in India. So, what are the repercussions of that? The pros and cons we'll be discussing in this article. And the second one is titled as Protecting Article 32, which is from the Indian Express. We have, in some of the other way, also covered this. Segment in our previous sessions as well, but today again some points were given regarding the importance of Article 32, so we will be discussing it in this article. And finally, we have the news and flash column, wherein we'll be discussing the small and crisp news points that are more important for our prelims exam. So if you're also preparing for judicial services examination, you can definitely have a look at the lot of the courses, which is a judiciary test prep course, which we have brought for you from LawSikho. The link is there in the description box of this video, and from the landing page, you can download free study material as well. You can also have a look at the other courses that we have for you, like for CLAT, All India Bar Exam, Judgment Writing, SEBI, etc. With this, let's see that what is the multiple choice question for the day. Under which article of the Constitution of India is the power to issue writs for the enforcement of fundamental rights is vested in the Supreme Court? So Article 31, second option is Article 32, third Article 33, or fourth Article 34. You can write down your answer in the comment section below. So this is the descriptive question for the day. RBI's proposal to allow corporate entry into banking. So why this step is seen as a risky proposition discussed. So recently, as we will be discussing, so we have to discuss as to what could be the repercussions of this step if taken. With this, let's start with the first article for the day, which talks about the corporates as banks. So recently, according to a recent report by an internal working group of the Reserve Bank of India, it is recommended that large corporates and industrial houses should be allowed ownership of private banks. Now, as we know that currently we have the banking system in India, the nationalization of banks had also taken place in the beginning of our economic era, and in that time, currently the system of banking that we have is that we also have the state-owned banks, like we have SBI, and obviously the mother of all banks, we have the Reserve Bank of India. But if we talk about the other banks, so for example, the State Bank of India is a state-owned bank. But then again, we have various banks that are privately owned as well. But now, this new proposal that has been given, but then now, the internal working group of the Reserve Bank of India has given this recommendation that the large corporates, that is the large businesses or the industrial houses, just like we can take an example of Tata maybe, or we can take the example of Reliance India Limited, for example. It has nowhere mentioned the names, but still we can take examples. So in a way, such large corporates or industrial houses would be allowed ownership of private banks. Now, obviously, there is a chance that this ownership might have a lot of repercussions, and we will be discussing it in this segment. But then let's firstly understand that what do we actually mean by the internal working group. So this can be a small question in prelims as well, as to internal working group is associated with. So you can get maybe options of SBI, RBI, Federal Bank, so and so. So the correct answer would be the Reserve Bank of India, which is the central bank of our own country. So basically, the internal working group, it was originally constituted to review the extant ownership guidelines and corporate structure for Indian private banks. So as in that, if we talk about the private banks that are functional in India, so who would be the entities, or who would be the people, or who would be the industry, be it anyone, who would be allowed firstly the ownership of these private banks in India, and secondly, what would be the guidelines of such ownership. So basically, this entire ownership and the guidelines or the regulation of this ownership is taken care of by the internal working group. So the function of the IWG should be kept very clearly in mind. So basically, what was the reason that we had brought the very system of internal working group, and why private banks are also still important? Though through nationalization of banks in India, a lot of private banks were turned into government owned banks, but still we realize that the private banks are also a very important part in the financial regulation of the country. So the reasons why we need this regulation of the private banks in India is, firstly, the total balance sheet of banks in India still constitute less than 70% of the GDP, whereas if we take example of China, it constitutes 175% of its total GDP. So in a way, it is important and desirable that the private banks in India function even better, so that they yield better and give better outputs as well. And in totality, they add in a greater extent to the GDP of the country. And that is why proper regulation of these private banks is desirable. Secondly, the domestic bank credit to the private section is 50% of the GDP, whereas in the case of China, Japan, US, and even Korea, it is approximately 150%. So in a way, the domestic bank credit means to the private section is that how much of amount, what amount of money is domestically credited to such banks, as in what total amount of money do these banks deal in, or they deal with. So that is why we need to increase their share, we need to increase the outreach of these banks, and that is why a proper regulation is looked up to. Now, if according to the IWG, the proposal is taken up and the industrial houses or the large corporates are allowed ownership of the private banks, then these would be the concerns that would be potentially raised. Firstly, the corporate houses can turn banks into a source of funds for their own business, cronies, suppliers, and customers. Now, this is a very simple thing that we can understand from here is, like, for example, if there is if for example any person is given the power to hold, for example, 100 rupees. Now that person is also owning his own business, and he also needs investment for his own work. Now, obviously, there is a high tendency that the person would prioritize his own industry, his own business, and would give the amount of 100 rupees or the larger amount of this 100 rupees for his own business or for his own growth. And that is why, if at all the corporate houses would be given the ownership of the private banks, then there is a very potential chance that these private banks would ultimately be used by these corporate businesses to source funds for their own business and growth. And that is why many a times the other customers or the other people who were earlier dependent on these private banks or the money from these private banks would now not be able to avail this money, and thus the economy might be hampered at large. Secondly, the interconnected lending, which means a situation where the promoter of a bank is also the borrower. So, which see, now currently what happens is, since they do not have ownership of any bank, so ultimately they have to look out for loans, and they take the loans from any kind of bank, now be it any central bank, as in be it any state-owned bank, or be it a private bank. But if at all they would themselves be the promoter, as in the ones who are looking or taking care of the functioning of that particular bank, and they are themselves the borrower of these banks, so in a way they would be giving or giving debts, or using the money for their own self. Now, a very good example can be taken here for the Chanda Kochar case, wherein she was alleged that she was giving a huge or hefty amounts of loans to her own husband's business. So because she was in a position to do that, so she was paying a lot of money for the business that was already owned by her own husband, which means it can be somehow said that the very power that she had in her hand was used by her own self in this regard, as she was the former managing director and chief executive officer of the ICICI Bank, and it was alleged that she was using her power and position to give or to pay, to issue huge amounts of loans and debts to her own company or her home-owned company. So it is somehow not exactly related to this, but yes, if at all the absolute power is given to only one entity, then obviously there is a chance that there might be absolute corruption as well. Thirdly, concentration of the economic power. Obviously, this is a very high chance that would happen because of the people who are the ones who are already highly, very rich in the country, and they're already owning the largest share of the economy, like our large corporates and the industrial houses. Then the entire economic power in the terms of banking as well would go in their own hands. Fourthly, pitting the regulator against powerful corporate houses could end up damaging the regulator. Now, for example, if at all, because we know the largest or the highest regulator of banks in India is the Reserve Bank of India, and there might be a chance that with such concentration or the huge concentration of economic power in single handed people or in single handed entities, even the regulator would not be able to function in an unbiased manner, and there might be chances that the regulator also ends up damaging its own self. And finally, exposure of safety net provided to banks, that is guarantee of deposit. So in a way, there are a lot of repercussions that are available in this thing, and thus corporate banks, currently it is debated that they should not be allowed, they should really not be allowed the ownership of these private banks in India. With this, let's discuss the second article for the day, which talks about Article 32 as the soul of the Constitution. Now, here again, we had discussed that in the case of Siddiq Kapun, who was a journalist and had been arrested while he was moving forward to cover the entire Hathras rape incident, and to talk to the victim families and the other people. But he was actually on his way to Hathras. He was arrested. So, in this case, while the Supreme Court was looking into his bail case, the Chief Justice of India had said that the lower courts in India were trying to discourage recourse to Article 32. Now, as we know, that Article 32 of the Indian Constitution is a very, very important fundamental right, and it gives the right and power to a citizen to move the Supreme Court if at all any of the fundamental rights of that person are abridged. Now here, what we need to know is these things can be quoted very nicely in any of the answer. These are very important cases when it comes to Article 32. So this is the entire crux of this article. So the Supreme Court regards Article 32 as a judicial power subject to the fundamental principles of administration of justice. Now, as we know, that the Supreme Court says that obviously Article 32 is a very, very important fundamental right, but just like other fundamental rights, it is not an absolute right, but still it is a very, very fundamental principle for the administration of justice, and in no way it should be demeaned or discouraged by any court of law or any other person for that matter. And then Chief Justice of India, M. Hidayatullah, in the case, it is in the time of 1970. So in the Tilokchand case, he said that Article 32 keeps open the door of this court and requires the states not to put any hindrance to a person. So in a way, again, the importance of Article 32 has been reiterated, and that it is equally available to every person, every citizen in the country. So, and then Justice M.P. Thakkar and Justice B.C. Ray in Kanubhai Brahmabhat case in 1987, they said that it's the time for imposing self-discipline has already come, and even if it involves shedding off some amount of institutional ego, which means that no any institution, no, as we know that obviously the Constitution is the most supreme body, the most supreme thing in the entire country or the entire sovereign India, and no institutional ego would be entertained above the value of Article 32 in the Constitution of India. So these are some questions that are raised regarding the Article 32, that even do the justice forget that Article 32 also provides the power to provide constitutional remedies. In a way, it should be understood that Article 32 is really the soul and, the heart of the Constitution of India. And even during the framing of the Constitution, the Constituent Assembly debaters, they had all reiterated about the importance of Article 32. And that is why the courts of law should also keep in mind that no any citizen of the country is denied the access to Article 32 or any other fundamental right for that matter. With this, let's see, what do we have for news and flash today? UP or the Uttar Pradesh clears love jihad law. So the love jihad law, which we had been discussing lately, it has been cleared by the UP government, and the draft ordinance, which is Uttar Pradesh Vidhi Viruddh Dharma Samparivartan Pratishedh Adhyadesh 2020, was cleared to check the unlawful religious conversions and interfaith marriages with the sole intention of changing a girl's religion. So the provision of jail term up to 10 years has been provided, and a marriage will be declared shunya, that is null and void, if the sole intention was to change a girl's religion. So let's see what future has for this law. With this, we are done for the day. We hope it was a good session for you. Stay tuned with LawSikho for such more sessions to come. Thank you so much.